is that antitrust suits that you would think should be brought don't get brought by the government. Suits that you think should be pursued don't get pursued. So can you speak to some of the barriers to effective antitrust enforcement that you see out there that you're familiar with?
Usually what is most challenging for enforcers is having enough resources. I mean, these guys are often outgunned by the big tech firms that have unlimited budgets. The former chief legal officer at Google said publicly that they had about $1 billion to manage any sort of legal risk that was presented to them as a company. And we have enforcers that even in these trials will have about 1/10 of the resources that any individual defendant that they're taking on might have. So put all of that on turbo speed when it comes to big tech, and the inequity in resources is quite stark.
Yeah, that's startling. $1 billion, and that's versus government enforcers who have the resources of the government. There are private antitrust suits out there, but usually it's government suits that we see. Is that because of the resource imbalance, do you think?
Yeah, I mean, it can be difficult to find a plaintiff's attorney that's willing to take on the risk. And again, when we're looking at bringing a suit against big tech, you are taking on not just the biggest giants of the United States, the biggest giants of the world that have unlimited resource. That can be quite intimidating for anyone who's running their own law firm.
Did your company bring an enforcement suit, a private enforcement suit under the Clayton Act? And if not, why not?
As a startup, and so we're not just trying to raise more and more money and build up more and more equity and debt over time, and so you have to sort of pick your battles.
I just wonder if it's time we start thinking outside the box a little bit, or maybe it's not outside the box. Maybe it's getting back to first principles, because this is, after all, how the Clayton Act was written. I mean, it was written to allow not just government enforcers, and we understand the importance of that, but it was also meant to allow injured private parties to get into court and have a real shot at enforcing the law and recovering damages, treble damages under current law. Maybe we ought to increase those damages awards. Maybe we ought to change some of the injury and standing requirements that the courts have imposed that I think, frankly, are not there in the text. The history of the Clayton Act.
We need to increase the incentives and rewards for bringing these lawsuits. We have bounties in other areas, such as securities laws. We can bring that into antitrust. So, and that's good on both sides, by the way. It's good for incentivizing the lawsuits to be brought. It's also good for deterring anti-competitive conduct because the penalties are greater.
Yes, exactly. Terrific point. Terrific point. And there's something that is, I think, particularly market reinforcing about private suits, because you have private actors who in real time are responding to harms. If they are properly incentivized and able to get into court to enforce their rights, that's good for the company. That's good for all of the other people who are in a similar position. It's good for the government. The government is not expending resources. It's good for the market. As it turns out, the people who drafted the Clayton antitrust law were pretty smart, actually. They had a good intuition 100 years ago, and maybe it's time that we made better on that promise.
It can also be quite scary to take on that public lawsuit for fear of retaliation. We know it's happening behind the scenes, but once you become the named party in a lawsuit, that can also heighten quite a bit that risk. And so I do think it's a both and. Funding the antitrust enforcers, making sure they have the resources to bring these suits on behalf of a lot of the businesses who can't for themselves, but then also encouraging private suits as well.
Having to face a jury maybe and with a competitor who's sitting on the other side of the table and facing a judgment that will run into the billions of dollars. I mean, it really gets the attention of these CEOs and, frankly, their shareholders. I remember the FTC fined Meta not that long ago. It was a pretty large fine. Meta didn't meaningfully change their conduct. Their stock price went up the next day after the fine was announced. I mean, it's ridiculous. How would they like to face like 1 billion lawsuits that could run into damage totals of tens of billions, hundreds of billions of dollars? I don't know. Seems like that was the intuition of the drafters of the Clayton Act.